All right, good afternoon, everyone. We can get started. It seems that we have a critical mass of folks assembled for the training today. Thank you all for joining. My name is Niquelle Allen, again, Director of Open Government, and I am your presenter today. This is my contact information. We are now located at 1030 15th Street Northwest, Suite 700 West. This is my email if you would like to reach out to me directly with any questions. And I'll reintroduce my colleagues again. I am joined by the members of the Office of Open Government, Louis Neal, our Chief Counsel, Anthony Skirbo, our Attorney Advisor, Brandon Lewis, our Attorney Advisor, and Kimberly Brown, our paralegal, and we are the Office of Open Government. Now, just a little bit about us. The DC Office of Open Government, we are in charge of the Freedom of Information Act, and we are the experts. So this is why we're having this training today. This is part of what we do on a daily basis. The Office of Open Government is empowered to issue advisory opinions on FOIA issues. The statutory theme for that, or statutory nomenclature for that, is we are responsible for ensuring the implementation of the DC Freedom of Information Act. We also serve as an advocate for a fair Freedom of Information Act process. We do that before the DC Council and also before the executive bodies. We also advise the entire district government on FOIA, and our board, the Board of Ethics and Government Accountability, issues an annual best practice reports that recommends changes to the FOIA law in the District of Columbia. We are also responsible for training public bodies, including ANCs, on the requirements of FOIA, ANCs, Advisory Neighborhood Commissions. We also assist members of the public in filing FOIA requests with the requisite agencies. So if you have an individual who is having difficulty making a FOIA request, you can always send them to us, and we will assist them with that process. Again, we advocate for the fair implementation of FOIA, and that's part of that responsibility. Now, the presentation today is designed for new FOIA officers and seasoned FOIA officers. We will look to take you through the life cycle of a FOIA request. So the presentation contents will be as follows. First, I'm going to give you a basic introduction to FOIA that will build off of the information you received last week from Chief Counsel Neal. Then I'll go into actually responding to FOIA requests. I will give you practical tips and also direct you through that process. Next, we will go through conducting searches for records and what that should look at. The last part of the presentation will be on producing the records and on the decision letters that you as a FOIA officer issue as a result of your search and through this process. Now, the District of Columbia Freedom of Information Act is a law that gives the public the right to access information from the District of Columbia government. So DC Freedom of Information Act, I will refer to in this presentation as DC FOIA or FOIA. And under FOIA, DC government must release the requested information unless it's protected from disclosure. DC FOIA also requires that agencies proactively provide certain information without a FOIA request. We'll go over that. That information is generally under the FOIA or Open Government tab on your websites. And it might be, since we're in person now, you may have to physically present the records if requested. DC government also proactively provides records and data on opendata.dc.gov. This is where you can send people for information, and it's a great resource to do so. And also that FOIA tab, if done correctly, which we know it is done correctly. Now, DC has what are collectively known as public records law. The overarching theme that we move upon is the public policy. So our public policy with regard to transparency means all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them. So our Freedom of Information Act was enacted in 1973. It's 51 years old, and it was designed to pierce the veil of administrative secrecy and to open agency action to the light of public scrutiny. So, as government officials, we want to ensure that the way we operate is transparent, and DC FOIA gives the public confidence in what we do because of that. And they have the right to request records that are prepared, owned, used in the possession of, and retained by a public body, which means a governmental entity. So when FOIA requests are submitted, DC agencies are required to make a reasonable search for those records. And also, on an annual basis, DC government agencies and U.S. FOIA officers are responsible for this, are required to report FOIA disclosure activities for the previous fiscal year to the Secretary of the District of Columbia and the Council of the District of Columbia. This is the FOIA report, the annual FOIA report. The DC Office of the Secretary is ultimately responsible for providing that report and contacts you sometime in the near future, around the beginning of the next fiscal year, to get that information. So make sure you're keeping accurate records of your FOIA activities throughout the year. So I'm now going to go into who's who in FOIA management. There's no central agency within the district government that handles FOIA requests. Each agency is responsible for processing its own records under DC FOIA. The primary contact for DC FOIA is most of you, the agency FOIA officer, and also the agency director. Another entity that you must know about, and I'm sure you're all familiar with, is the DC Mayor's Office of Legal Counsel, or the MOLC. The MOLC handles FOIA appeals, and those are FOIA administrative appeals. The DC Office of the Attorney General, OAG, handles FOIA litigation through its Civil Litigation Division. OAG also provides FOIA advice through its Legal Counsel Division. The most frequent entity that utilizes that FOIA advice is Advisory Neighborhood Commissions, but any agency may come to us or to OAG for legal advice about FOIA. More who's who. The mayor of the District of Columbia created an entity known as the Open Government Advisory Group, or OGAG. This group advises the mayor on FOIA and other open government and transparency issues. It includes subject matter experts from the government and also members of the public with expertise and interest in open government. Now, what is an agency's FOIA responsibility? Well, each agency, usually the agency director or general counsel, must designate an individual as its FOIA officer. The agency must let the public know who that person is. So on the agency's website, the name, title, address, telephone number, and email address of its designated FOIA officer should be available to the public. Now, I know there are some agencies that have an email that's a general FOIA email. That is acceptable, just making sure it goes to the FOIA officer and that that FOIA officer's identity is known to the public. So if they have a problem, they have someone to contact. So the agency FOIA's officer's responsibility is as follows. You as FOIA officers are responsible for tracking, managing, and responding to FOIA requests for records in your organization's possession and control, and you're responsible for administering your agency's FOIA programs. You, as a FOIA officer, must conduct or coordinate a reasonable search for records and respond timely to a FOIA request. Now, depending on the size of the agency, you may have multiple individuals who work on FOIA, but the ultimate responsibility falls on that agency director and on the FOIA officer for producing those records. Now we're going to move into FOIA requesters and the actual FOIA request. So who may request records? Any person has a right to inspect and at his, her, or their discretion to copy any public record of a public body except as expressly provided by the FOIA exemptions or exceptions. So we do not restrict anyone from making a FOIA request. We are now even looking at, whether AI can make a FOIA request, which we haven't answered yet, but that question was asked in the last training. We do not restrict who can request records. Like our sister state in Virginia, I think you have to be a Virginia resident to request records, but we are broad and allow any person to request records. And it should also be noted that there's no identification requirement. They don't have to give you information about themselves to make a FOIA request. They just make a FOIA request. You can reasonably request how to get in touch with them, because how else are you going to respond to the request? But there's no obligation, for example, for someone to show an ID to collect records. That has come up before in the past. So now, how can records requests be submitted? They can be made orally or in writing, but they have to be directed to the particular agency. You may request that the FOIA requester submit a written request for your records. These requests can be mailed, faxed, or emailed according to the regulations. From what I've seen, most FOIA requests are sent either through the FOIA portal, which I'll discuss briefly, or through email. And when you get calls in your office, it is, again, advisable and permitted for you to get those in writing. And writing now is usually an memorialization by an email to the FOIA officer. So the regulations can be accessed at dcregs.dc.gov, and one DCMR section 400 at SEEK contains the rules and procedures to be followed by agencies regarding FOIA. So make sure that you do take a look at those regulations, and we will provide those for you if you can't find them. I believe they're on our website, open-dc.gov. There should be a link there. So the actual request, going back to that, the request must reasonably describe the desired record. If possible, specific information regarding names, places, events, subjects, dates, files, titles, file designation, or other identifying information shall be supplied. So the most important thing a FOIA requester must do is let you know what they're looking for. The example I give is if you lose your keys and you need someone to find them in lost and found, you give specific information. You tell them the color of the keys, how many keys, if it's on a key ring. Those are the types of things a FOIA requester should be letting you know about so you can locate what they are asking for. So what are the type of records they may ask for? Number one, most frequently, would be those email messages. Those are our frequent requests are for email messages. Text messages, they may request those. Notes, databases, files, communications, camera footage, that's generally body-worn camera footage, video footage, the same, and photographs. Now, what is considered a public record under FOIA? This is changing and broad, but it is defined in the DC Code. And it tells us that as government officials, we must provide access to public records to maintain an open and transparent government. And these include all books, papers, maps, photographs, cards, tapes, recordings, voice data, including ballot definition material, raw data, and ballot images, or other documentary materials, regardless of physical form or characteristics, prepared, owned, used in the possession of, or retained by a public body. Public records include information stored in an electronic format, and that electronic format definition now includes text messages and even some applications that are on phones, and it will also include information concerning social media and social media sites maintained by the agency. So, as a FOIA officer, you should always keep in mind that is a broad definition of public records, and it is our public policy to be transparent. So anything that someone is keeping, unless it's subject to an exemption, might be subject to DC FOIA. Records of some contractors might be public records that are subject to FOIA. So if those records are produced or collected pursuant to a contract with the district government to perform a public function, those records may be subject to FOIA. Now, as I alluded to earlier, you should have a FOIA or Open Government tab that includes links to information available without a FOIA request. So the idea behind this is this information should be readily available. They should not have to ask for it. Under FOIA, it should be somewhere where the public can find it. And these include the following: employee salary, title, and employment dates. For those of you who don't know, that information is available on DCHR's website. DCHR is doing a great job now, so you can just type in my name and everything that about me and my employment with DC government will come up, any of our names. So most websites do have a link to employee salary, title, and employment date information, which is on DCHR's website. Contract expenditures, that information should be readily available. It is usually on OCP's website, so your website can direct people there. Budgets, manuals, policies, rules, opinions, orders, and the other function of our office, meeting minutes of open proceedings of public bodies. So I did mention earlier, but some of you may know that the Office of Open Government is also responsible for the Open Meetings Act and making sure that's followed. So if any of you all are in agencies that support public bodies, you will be ensuring that the meeting minutes are also on this website and readily available. And so next, we're moving into kind of the meat of the presentation, which is responding to FOIA requests. I am hoping through this discussion to guide you through the process. I see that there are some questions. Hopefully my colleagues are answering them. But I look to give you all the information you need to effectively respond. So the person who must receive a FOIA request and starts the clock is you, the FOIA officer. So when an agency FOIA officer receives a FOIA request, the FOIA officer should acknowledge receipt of the request via email or other initial communication to the FOIA requester. Now, if you are in our automated system, this would happen automatically. But if you are sent it again, an email, receiving an email or other correspondence, I recommend responding in kind. So as I just mentioned, we have an automated system now provided through GovQA, which is brand spanking new. The public may use this system to make FOIA requests, and DC agencies may use the system to process those requests. It should completely automate the DC FOIA process, but to the extent that it does not, you may always leave the system and communicate with the FOIA requester directly. I'm not as familiar with GovQA as I was the previous system, but if you have any questions about GovQA or if you're on it or how to get on it, you should direct that to Tang Nguyen at the Office of the Chief Technology Officer. So the FOIA officer should assign the FOIA request an internal tracking number or use some type of system to keep track of the FOIA request if your agency is not using the automated system. As I mentioned earlier, at the end of the year, you're going to be responsible for reporting your stats to the Office of the Secretary for reporting at the end of the year. And if you're keeping track with some internal tracking mechanism for all your FOIA requests, it will make things much easier at the end of the year, and also especially our larger agencies, so that our external partners or FOIA requesters will have a number to reference to you when inquiring about their request. The automated system would provide it just as a matter of course. But if you're not using it, you need to make sure that you have some mechanism for tracking the requests you receive. Now, an initial correspondence would include an introduction, acknowledgement, any clarifying questions. So as I said before, that FOIA request needs to be specific so that you can find the records. So that initial response could be including questions to clarify that request. If you have fees that you know about already, you may start the discussion of fees in this initial correspondence, or it could come later. Again, that tracking designation, make sure it has your contact information. Again, this is for questions, a complimentary close, such as sincerely, we like to be polite in government, and your type name, agency, and your title. So you would provide a signature, I guess, if you were writing an actual physical letter, but your contact information block is sufficient for that reason if you're using email. Now, timing. We do have a specific time frame in which we must respond to FOIA requests. For records other than body-worn camera recordings, the time you have to respond is 15 business days. If you have a request for body-worn camera recordings, it's 25 business days. And this is your final response. You may extend that final response by saying that an unusual circumstance exists. So an unusual circumstance will provide additional time for you to respond if you provide a written notice to your requester and you set forth the reasons for the extension and the date for your determination. So the unusual circumstance is defined by the DC Code. DC Official Code Section 2-532D2 says you may extend the time to respond if you need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request. This is usually emails. When you have an email search request, usually brings a large volume of email records. So this would be a time when it's appropriate to invoke that extension. The second unusual circumstance is a need for consultation, which shall be conducted with all practical speed with another public body having a substantial interest in the determination of the request, or among two or more components of a public body having substantial subject matter interests therein, or if it's a body-worn camera, if the recording if you cannot procure the recording from the vendor and they're unable to perform redactions within the 25 day time period. So those are the three instances in which you can invoke an extension of time to respond to the FOIA request. So if you're using the automated system, the feature is included. Outside that system, contact the requester with written correspondence that details a specific statutory justification for that extension. The consequence of not responding timely to a FOIA request is it's deemed denied. The requester can immediately file an administrative appeal to the MOLC or file an action in DC Superior Court. And so now we're going to go over dealing with problematic FOIA requests. So what if I receive a request that's overly broad? The regulations provide that a request shall reasonably describe the desired record, where possible, specific information regarding names, places, events, subjects, dates, titles, file designation, or other identifying information shall be supplied. So, the DCMR states where the information supplied by the requester is not sufficient to permit the identification and location of the record by the agency without a reasonable amount of effort. The requester shall be contacted by the FOIA officer and asked to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification and the location of the requested records. So how does this impact your deadline? It tolls it. So the language here is that request is not deemed received by the designated FOIA officer if the information is not there to permit the FOIA officer to locate the record. So when you contact the requester for more information, it is deemed received when you receive that additional information. So the time deadline is told until you receive the information from the requester. So again, in my analogy about the keys, if they just said, I lost my keys and that's it, and you say, well, how many were they? What did it look like? I need more information. Until they respond to you with that response, you don't have to fulfill that request because you cannot. They are responsible for giving you all the information that you need to be able to conduct a search for the record. Now, what if they never respond? This happens. We have given unofficial advice about this, and this is our advice. Contact the requester at least 3 times before closing the request for lack of response to a request for clarification. So in this instance, you are assuming they abandoned their request. We suggest that the FOIA officer contact the requester regarding the clarification again at least 3 times and give them 2 weeks to respond each time. After the third contact and the 2-week time span, you can administratively close out the FOIA request if no response is given and assume the FOIA requester has abandoned the request. Make a note of this in your files and your attempts to contact the requester. So again, you're giving them every opportunity to respond, to make sure that you're able to find this record. But if you don't hear from them, we think it's reasonable for you to deem the request abandoned after a certain point. So what if the request is overly burdensome? Well, under DC FOIA, there's no authority to treat the request as void because DC believes it's overly burdensome. Now, I will give one caveat to that. Now, if you have an electronic request and the system burdens your computer to the point where you're not able to function, if you contact Octo, have Octo provide an affidavit, and it is very specific and it actually happened, not meaning it might happen, it has actually happened, Kate's law suggests that you can deny a request on that basis. But this is a very specific circumstance. And again, you have to have evidence. This can't be proscriptive. It has to be actual. We are releasing an advisory opinion on this matter in the near future, and I'll make sure all of you get a copy of it. It'll be on our website. Voluminous email productions. Now, if you are required to review a large number of emails, it's definitely going to take more than 15 business days. Um, the courts have recommended that you contact the requester and work out a production schedule. In an attempt to produce the first batch within the first 15 business day um, is suggested, and releasing the records in according to the schedule you agree upon with the requester. For example, you say, look, this is huge. This is my whole job to review these records. It's going to take me a couple of months. I can produce a record for you once a month or once every 2 weeks. That's something that you can agree upon with the requester. It's still technically a denial, and as we stated earlier in the timing portions, they can still appeal, but it shows that you're acting in good faith as a FOIA officer and you're trying to fulfill their request. There is no remedy available, again, this denial for being burdensome on government resources, unless I said with the caveat it truly is, and you have OCTO um, saying it is. But we try to review, because it does take a long time to review all these emails and when you get a lot of them. So the court has just said it's important for us to maintain that contact and act in good faith. The next area I'm going to touch upon is searching for records. The search for records involves everyone who maintains records. This is not your sole responsibility as a FOIA officer. All agency employees who maintain records are responsible for assisting the FOIA officer with the identification and search of responsive records. So, where do you start? Agencies are supposed to have a designated records officer or a person that's designated or responsible for maintaining the agency's records. That employee specifically should assist you with locating the record requested. Examine your agency's org chart, and it may provide details about who may possess a particular record. Again, if the request is for email or other electronic record that OCTO maintains, you may have to request it through your general counsel. Also, make sure you look at your retention schedule to make sure the record requested has not been archived. And you can find those retention schedules on the Office of the Secretary's website if it's been approved. Now, a FOIA officer is required to conduct an adequate search for records responsive to the FOIA request. This is what you're required to do. It's always, again, acting in good faith. So in assessing whether the district conducted an adequate search in response to a FOIA request, the courts do not look at the fruits of the search, but to the appropriateness of the methods used to carry out that search. So again, acting in good faith, making sure that you have looked at the records in an appropriate manner, a manner that's reasonable and expected. So the issue to be resolved is not whether there might exist any other documents possibly responsive to the records, but whether the search for those documents was adequate. That's the standard upon which you're held. An agency search conducted in response to a FOIA request doesn't have to be perfect. It's measured in the reasonableness and effort in light of the specific request. And the search must be reasonably calculated to uncover all relevant documents. So when we have a later training, the Office of the Attorney General Civil Litigation Division will go over the specifics of this. Um, but it's important, and it might be beneficial to your agency if you're in litigation to have an affidavit or some other declaration of how you conducted that search. So if an requester ever challenges whether you conducted an adequate search, the agency is required to establish beyond a beyond a material doubt that it expended reasonable efforts to uncover all relevant documents by setting forth sufficient information in its affidavits for a court to determine if the search was adequate. So, as a matter of best practices, as an agency FOIA officer, you could create an affidavit or declaration that describes your agency's search for records. Now, this would be helpful, again, because we have changes in personnel, changes in FOIA officers. So if there's a document that says, okay, I did X, Y, and Z, and you're no longer there, the agency will be able to reasonably argue that the search was adequate. So again, what should my affidavit include? You provide the context for the request, describe the structure of the agency's file or record keeping system, electronic, paper as applicable to the request. Does the agency have a retention policy? Was a search conducted even if the retention policy called for the disposal of the record? So you're basically listing what did you do. If you are not as an attorney and there's a need for you to do this, please consult with your agency's general counsel or assistant agency counsels to help you with this. And the agency again must describe, at least generally, the structure of the agency's file system, which makes further search difficult. So again, an example of this could be having to reach out to Octo, the voluminous amount of records that were requested. Another example could be that a requester asked me to have specific search terms and I wasn't able to do that. Another example of what could be in a declaration or an affidavit is that all my agency's files were in paper, and those paper files were sent to archives. And I called archives to search for the records. I'm still waiting for them, or archives couldn't find them. So again, you're talking about what happened, what you did, what the records were like, what made it difficult for you to continue to search. So again, this is explaining the agency's search was reasonably calculated to uncover all relevant documents. So you'll detail both how the search was conducted and your reason for doing it that way. If only one system is searched, make clear that that system is the only possible place that responsive records were likely to be located. Again, email searches, again, reasonable. I put this picture here because I don't know if many of you know, I used to be with the Office of Chief Technology Officer. I was a FOIA officer before, and I was responsible for all the emails, including my agency's emails, and sometimes it's difficult. Um, so you just sitting there with this large body of emails, and you have 1,000 other things to do. Um, just no, we hear you, and it's not the easiest undertaking. So we do not, so this is what the court has said about that. We do not know and cannot simply assume in this age of computerized connectivity that it would be unreasonable for the agency's FOIA officers to search all the agency's email accounts, regardless of how many accounts that might be. So as you may know, DC has retained all of its emails since 1998. So an email search for a specific email box from a specific employee, especially one who had been here a while, could yield a large amount of documents. But the courts have not given us any relief in that respect. They expect us to search through those emails and produce the relevant ones that are not subject to an exemption. And so more on affidavits for requests involving email searches. This is affidavits concerning where the request was for email. Explain how many email accounts exist and what the agency and or Octo's capacity is in terms of searching them. Consider having Octo submit an affidavit on your behalf detailing where and how it searched for responsive records. If it's unreasonable for Octo to conduct searches, then Octo will have to explain why. So fees, as you know, you may or may not know, as I'm letting you know today, you may charge a fee for a FOIA request. Um, Usually, if you get a request from a journalist, they will have a fee waiver baked in that because it's in the public interest. But absent that, you may charge a fee for conducting a search. You need to make sure that each person assisting with the search, keeps a log or other documentation of the time spent prepared searching for those records. There in the DCMR, there is a schedule of how much it costs per employee per hour to do a search, and that's how you would estimate those charges. So the agency can charge fees for conducting searches and producing records. There's no fee to submit a request. But you could require a requester to pay fees in advance. For example, if they have not paid past FOIA related fees or if they owe the district money. And as I just alluded to, you can grant a public interest waiver of fees. And that's very specific. They have to ask for it. It's not something that you have to affirmatively suggest. So here's an example of the types of fees that are listed in the DCMR. As I've just mentioned, searching for records, hourly rate based on the type of personnel, the grade of personnel who perform the search. Photocopies, you're probably not going to see that as often these days. It's 25% per page. Document certification, $1 per document to certify the document as a true copy of an agency record. Direct cost of any service or material for which no fee has been established. Example of that could be with recordings um, that have to be redacted. There's no specific DCMR provision for that, so that could be the actual cost. A requester may have to pay search and review fees, even if the search doesn't locate responsive records, or if the records are located but they're withheld as exempt. FOIA exemptions. Now, as I've alluded to, you should determine once you receive the records that you search for, whether the agency has to release them in full or in part. They may be subject to a FOIA exemption. Categories of exemption. Exemptions under the DC Act are patterned on and have been construed in accordance with federal law. So a lot of times we are able to use federal cases to help us interpret DC laws if the federal law and the DC law are the same. And this is a good way to evaluate your exemptions if it's not clear whether or not you can use it. So exemption one, this is one that is different on the federal side, is trade secrets. Trade secrets and commercial or financial information obtained from outside the government to the extent that disclosure would result in a substantial harm to the competitive position of the person from whom the information was obtained. So this is usually going to come into play if you have a contract, if you used a contractor to create a report or some type of proprietary document, this exemption could come into play. So if you think about it logically, if you bid for a district contract and kind of all your secret sauce is revealed, someone else may be able to come in and use your information or publish it or do whatever with it because we made it public. So that's the type of information this exemption is used for and the reason. The second is one that you will see most often. I think this is our most used or second most used exemption. It's exemption two, personal privacy. So it's personal information personal private information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. So as individuals, we provide information to the government. As government employees, we have interest in certain information about us that we should be able to be sure the government will keep private. So these are that's the type of information that can be redacted or withheld in its entirety under the personal privacy exemption. Like, for example, if you have a record that has Social Security numbers, you of course would redact that. If it's addresses or things of that nature, that would be redacted. Another example is resumes that you receive from people who are applying to the district government. You can withhold that type of information or information on those records from exemption 2. So, what you're required to do with personal privacy exemption is conduct a balancing test. And the individual's privacy interest in the material at issue must be balanced against the public interest in disclosing it. And this public interest must serve the core purpose of shedding light on an agency's performance of its statutory duties. One case that's important here is In Re appeal of the Washington Post Company. The privacy interests of students and teachers under investigation for the consumption of alcohol substantially outweighs the public interest in their identifying information. Another example is In Re appeal of Walter Thomas may disclose names, professional qualifications, and work experiences of a successful job applicant, but refuse to disclose other private information such as home telephone numbers and addresses, social security numbers, marital status, and personal references, or any information regarding unsuccessful job applicants. Exemption 2A concerns body-worn cameras. Any body-worn camera recordings by the Metropolitan Police Department that are inside of a personal residence or related to an incident involving domestic violence, stalking, or sexual assault as as defined by the DC Code is exempt. Exemption 3 is law enforcement. So that means investigatory records compiled for law enforcement purposes, including records of the council investigations and investigations conducted by the Office of Police Complaints. Also exempt are investigatory techniques and procedures not generally known outside of the government or endanger the life or physical safety of law enforcement personnel. Exemption 4 is agency communication. Records might be exempt from disclosure if they're interagency or intra-agency memorandums or other letters which would not be available by law to a party other than the agency in litigation with the agency, other than a party in litigation with the agency. I think that might be a typo. So here again, we are looking for final records. We're also looking to allow the government to be able to conduct its business. So we encourage exchange amongst our agencies, and these types of letters or memos are able to be shielded from the public because we want to encourage communication amongst the government. Exemption 5 and 6, future examination test questions. That's pretty self-explanatory. We don't want to give the answers to tests out before the test is taken. Exemption 6, other statutes can't be a regulation. That's information, specifically exemption from disclosure by statute other than FOIA, provided that such statute requires that the matters be withheld from the public in such a manner as to leave no discretion on the issue or establishes particular criteria for withholding or refers to particular types of matters to be withheld. Exemptions 7 through 9, national security measures under federal law. This would usually have to do with our law enforcement agencies, antitrust investigations, exemption 8, and arson investigations. Again, these all tie into public safety reasons for why we're not releasing records. Exemptions 10 through 12, emergency response plans, Social Security, and federal employee ID numbers, whistleblowers, unless the name of the employee is already known. So whistleblowers are entitled to protection of their identity, again, to make sure that they do not have blowback from what they have revealed. So they are required to be kept anonymous or just withheld from public disclosure. Exemptions 13 through 15, Homeland Security records, sealed criminal records, and critical infrastructure. Again, going to our public safety, we do not want to reveal the location of our physical plants, of our plans, our water systems. Again, this is tied to national security to make sure that those vulnerabilities aren't revealed to the public or just individuals outside of the government, I should say, that might use that information for a nefarious purpose. Teacher evaluations are exempt. That's exemption 16. And then we have finally our legal exemptions. So these are the same legal exemptions that are used in court. First is attorney work product. This applies to documents prepared by or for an attorney in anticipation of litigation, no matter the status of that litigation or the stage of that litigation. Attorney-client privilege protects confidential communications between an attorney and client when the agency is the client and when the privilege is necessary to obtain legal advice. Deliberative process privilege. This is the method through which an agency creates policies, opinions, rules, and regulations. To qualify for this exemption, a record must be both pre-decisional and deliberative. So pre-decisional documents are those generated before the adoption of an agency policy. A document is deliberative if it's part of an agency give and take process by which the decision itself was made. So for example, one example that's in court is our budget process. So as some of you may know, when the budget is being decided, there are a lot of documents that go back and forth that lead to the final product. The government has said these are deliberative. We haven't made a decision about it, so those aren't subject to be released. Again, the reason is we should be able to have discussions before we have our final documents and recommendations. And this is one of the exemptions that can be used for that. And that's the reason behind it. Third-party communications. The deliberative process does not generally apply to communications that include third parties. It applies only to inter and intra-agency documents. So, for example, if you're meeting with the public, again, it's saying, well, it's not confidential. You have someone else involved. So we may not be able to use that deliberative process exemption in that sense. Communications that include third parties may only be withheld under the deliberative process privilege under the consultant corollary. If the third party has no independent interest, their interest is aligned with the government, then you might be able to withhold the record under the deliberative process privilege. This is similar to when I gave the example about a contractor who's working for the district, and those records are subject to the same legal theories as those of the government because they're stepping in the shoes and acting as the government. In a typical case in which a court applies the consultant corollary, the consultant does not represent an interest of its own or the interest of another client when it advises the agency that hires it. The only obligations are to truth and its sense of what good judgment calls for, and in those respects, the consultant functions just as an employee would be expected to do. And the court said that in McKinley versus Board of Governors of the Federal Reserve System. Similar, analogous federal case. This one, very likely that you would be in this position unless you're law enforcement. So GLOMAR responses. So I can neither confirm nor deny the existence of responsive records. So acknowledging the existence of records would divulge protected information. A search may not be required if all potential responsive records are entirely protected. Use caution here. Requests can also include responsive non-exempt records. So this is a very specific, usually to law enforcement. Also are some of our executive functions to where we would use the GLOMAR response. Now we move to the final part of the presentation, producing the records. A FOIA response does not have to provide answers to requesters' questions disguised as a FOIA request in response to an individual's request for information. The agency's obligation in meeting a FOIA request is to provide access to its records. So in your records production, you do not have to answer questions if they are embedded in the response. All you need to do is provide the records. Do I have to create records? No. FOIA does not require an agency to create any documents or issue opinions in response to an individual's request for information or to obtain records from another agency. So in this instance, if you do not have the records, let's say you are an attorney or a FOIA officer from DDOT, and the records are held by DPW, you have no obligation to provide records that your agency does not have. In that instance, you will refer the request to DPW, but you don't have to. You should refer to what is required in an agency decision letter. An agency decision letter should include whether the record was released in full, partially released, redacted in full, or would be withheld in full. Let me step back. We're not talking about redaction, but if everything is redacted, do not send anyone a black page with all of the writing blacked out. You would just withhold that record in full. Um, it must include the name and contact information of the person that made the decision concerning the release of records, a reference to the DC code provision that is the basis of the decision. This is if you are withholding records or have redactions, and a statement advising the requester of their appeal rights. So stating that, letting them know that they can appeal the decision to the MOLC or they can file a civil action in DC Superior Court. So do not use vague language in your denial request. Keep it, denial of the FOIA request, keep it very simple. Don't say if construed as a denial, it either is or it isn't. Do not withhold multiple records using multiple exemptions within a single omnibus sentence. I.e., agency is withholding all responsive records pursuant to 1, 2, 3, and 4. You need to specify which exemptions apply to which records, or if you're doing redactions, which exemption applies to which redaction. So we've reached the end of my presentation. So this is the FOIA process in a nutshell. You receive a FOIA request. 2, you process the request. So you log it internally, create a case file, estimate fees, send an acknowledgement. The next step is retrieve the records, conduct a search for responsive records, request records, and then review records. The next step is you process the records. That means you would make redactions based on the exemptions that I just named and calculate the final fees. And the last step is approve the release of records or deny the request. You would draft a response letter that includes the fees or the grant of a fee waiver and release the record or not after you receive the fees if applicable. So I will mention if you are charging fees, you're not required to release the records until they pay your fees. So this is, again, the Office of Open Government. We provide advice to agencies, members of the public on the Open Meetings Act and the Freedom of Information Act. Our email is here, or you can call us. Staff members are myself. I'm Niquelle Allen, the director. We have Louis Neal, our chief counsel, Anthony J. Skirbo, our attorney advisor, Brandon W. Lewis, attorney advisor, Kimberly Brown, paralegal specialist, and Kevin Brown, IT specialist. If you need help with our website, Kevin is the one to contact. So I'll also mention that we have 3 additional courses. Our next course is commonly used FOIA exemptions. That's happening on July 30th. Next, we have the FOIA litigation update. That's going to let you know what's happening in the world of FOIA, that update you on some cases. And lastly, we have the Office of the Attorney General preparing for a FOIA case, defensive litigation, and that's on August 13th. We hope you'll be able to join us for our remaining courses, and that will fill in any gaps I've left by my presentation today. So now I guess if we haven't had all the questions answered, I can take some questions, but I would like to end with saying thank you again for serving as a FOIA officer and for your attention today.
So, Director, we did have a comment that was made relative to body-worn cameras. The attendee mentions that corrections officers carry body-worn cameras, but the exemption focuses on MPD only. And shouldn't there be an amendment to the exemption? That's a statutory issue for the council to decide. The exemption specifically is made for MPD and does not deal with other agencies that use body-worn cameras. So that's properly addressed, by the Office of Legal Counsel and by the council itself. We take no position on that. And then the other question is, guidance provided regarding internal investigative documents that aren't for law enforcement purposes, but might be for either agency deliberation or edification. And is there an exemption that attaches to this? As the chief counsel correctly points out, more than one exemption can apply to a set of facts. For example, the privacy exemption may apply as well as deliberative process. Certainly in terms of edification, the deliberative process privilege may very well apply. If there's a specific scenario or hypo that you wish to discuss, we're certainly available offline for further discussion. And that's all the questions we have in the chat.
All right. Thank you for that summary, Attorney Skirbo, and thank you everyone for your attention. I do see one question that just came in to me regarding fee waivers. What discretion does an agency have regarding fee waivers? Is an agency required to grant a fee waiver? The answer to that question is no. An agency is not required to grant a fee waiver. There's a whole analysis that you can go through to see if it's in the public interest to grant the fee waiver. And that is what you should follow. I can provide additional information if you send me an email on the specifics of the fee waivers. And I believe we do have an advisory opinion on our website about fee waivers. So seeing no other questions, I want to again thank you. Yes, I'll send it to everyone. I want to thank you for your time and for your attention today and for your service as FOIA officers. It's an important job. It's not always one that's given the attention and respect that it should, but you are doing a great service to the District of Columbia and keeping it open and transparent. So hopefully we will see you at our next training on the 30th. And with that, we will adjourn. Thank you, everyone, and have a great rest of the day.